Hi, good morning to everyone in various parts of the country and parts of the world. I'm Muzaffar Chishti. I direct Migration Policy Institute's office at New York University School of Law, and I'm here in Washington, D.C. on a very bright morning, and we are so glad that all of you found time to join us. We are doing this webinar because the Supreme Court is hearing an argument on Monday morning on an extremely important landmark immigration case called U.S. versus Texas. You will hear more about the case and its ramifications in a little while, but the presentation today is called DAPA, Imbalance, Supreme Court Arguments and Potential Impacts on U.S. Families and Communities. DAPA, if you don't know, is a short acronym for Deferred Action for Parents of Americans and Lawful Permanent Residents. Before we get into our presentations, let me just do a couple of housekeeping notes. The audio from this webinar will be available today on our website, and our website is migrationpolicy.org. The report that my colleague Randy Capps is about to introduce you to, called Deferred Action for Unauthorized Immigrant Parents, Analysis of DAPA's Potential Impact on Families and Children, will be available, is actually already available on our website. To give credit to all the authors, it's been authored by Randy, by Heather Kobal, by James Bachmeyer, by Ariel Ruiz Soto, Ji Zong, and Julia Jalad. If you have any technical problems today, please email at events@migrationpolicy.org or call us at 202-266-1929. And if you have any problems hearing the web, please dial in using the call-in information we have sent you via email. And we'll have a written question and answer session at the end of the presentations. Please type any questions into the Q&A or the chat box on the right side of your screen and send it to the host, or email to events@migrationpolicy.org, or tweet your question to @migrationpolicy or #MPIDiscuss. So let me now turn to the main part of our program this morning, and to do this program, I'm joined by two of my very distinguished colleagues. Randy Capps is the Director of Research for MPI's U.S. programs. He has done demographic research on immigrants and families for over 20 years and is considered one of the leading experts in the country on those populations. Cristina Rodríguez is the Leighton Homer Surbeck Professor of Law at Yale Law School, and to this discussion she brings two unique perspectives. She worked at the Office of Legal Counsel in the current administration. She was also a Supreme Court clerk to Justice O'Connor, and she is an MPI non-resident fellow. So let me just so that they save a little time, provide a little context to the debate today. President Obama in 2012 announced a program to give protection from removal and work authorization to kids who had come to this country before 2007 and when they were children. You'll hear more details about their eligibility in a while. This program was called the DACA program, and that has been in effect since 2012. In November of 2014, after it was clear that Congress was not acting on the immigration reform, the President announced a series of executive actions. And the one that has gotten the most attention and is the subject of today's conversation was called DAPA and DACA Plus. DACA Plus essentially increased the number of people who would be eligible from DACA by removing the age limit on people's eligibility and by extending their continuous residence to January 1st of 2010. DAPA, on the other hand, is not about kids, it's about adults and people who have entered the country before 2010 and have been in physical presence in the U.S. since the day the executive action was announced, which is November of 20th of 2014, and have a son or a daughter who is a U.S. citizen or an LPR, is eligible to be a beneficiary of the DAPA program. The DACA program initially is going into effect and was never successfully challenged. DACA and DAPA, DACA Plus and DAPA are the subject of the litigation when a federal district court judge in Texas enjoined the government from proceeding with the implementation of that program. That case was taken up to appeal to the U.S. Court of Appeals of the Fifth Circuit, which upheld the injunction. And in end of last year, the federal government took an appeal from that to the U.S. Supreme Court. The U.S. Supreme Court granted the cert in that case, and the oral arguments on that case are going to be happening on Monday of the coming week. So what is the impact of DAPA Plus and DACA on the communities is what my colleague Randy Capps is going to highlight, and my colleague Cristina Rodríguez is going to tell us about what we expect the legal arguments in this case to emerge as. So without further ado, my colleague Randy Capps.
Thank you, Muz. Thanks so much to everyone for joining us today. And I would like to also thank my co-authors, whom Muz already acknowledged. This was a joint report of MPI and the Urban Institute, also based in Washington, D.C., also with collaboration from some researchers in Pennsylvania, including author James Bachmeyer and his colleague Colin Hammer at Temple University, and Jennifer Van Hook, who's the director of the Population Center at Penn State University, who advised on the methodology. The data we used are taken from two Census Bureau products, the 2008 Survey of Income and Program Participation, or SIP, and the 2009-13 American Community Survey, or ACS. The SIP actually asks immigrants about their legal status, whether or not they have either citizenship, a green card, or another valid visa, and that allows it to identify unauthorized immigrants who do not have a valid visa. We use information on other characteristics of people who are unauthorized in the SIP, such as residence, for example, from origin, Mexico or Central America, years of residence in the U.S., age, education, and other factors, and then find people in the American Community Survey with similar characteristics. The statistical technique used to link the two surveys is called multiple imputation. So using this method, we are able to identify unauthorized immigrants as a whole, and then within that, we identify the subgroups that are eligible for the different deferred action programs. So we previously identified those eligible for DACA. As Muz mentioned, the 2012 program that's in effect is for unauthorized youth ages 15 to 30 with at least 5 years of continuous residence who arrived in the country before age 16 and either graduated from high school or still in school. That's the program in effect right now. There are 2014 expansions that we model as well. That is one of the enjoined programs. The other enjoined program, as Muz mentioned, is the DAPA program for unauthorized parents of U.S. citizens and LPRs. Now, importantly, the way we define these populations, and the subject of the presentation today is the people who are only eligible for DAPA, only eligible for the parents program. We assume that those who are eligible for both programs would already have applied under DACA if they were going to do so. So today, I want to go through several things. First, our estimates of the number of people that are eligible for the DAPA program and the total number of people that live in households with them. Second, to describe the characteristics of potentially eligible individuals and their families. And third, to estimate the impacts on families of DAPA's two components. The first component is eligibility for work authorization, and we assume that with work authorization, parents might be more likely to work, and they might earn higher wages because they might get better jobs. So we look at that. Secondly, DAPA protects them from deportation. So we also look at the potential earnings and income losses to families if a father were to be deported. So to begin with, our estimate is that about 3.6 million unauthorized immigrants are potentially eligible for DAPA. This is above and beyond the DACA program, where we believe with extended DACA, an additional 1.5 million would be eligible. These parents are, within this group, we have two subgroups. 3.3 million parents still live with their minor children who are either U.S. citizens or lawful permanent residents in the same household, and we identify them based on their residence in the same household. But there are also some parents of older children. The children don't have to be under 17 for the parents to qualify for DAPA. And these parents generally don't live in the same household, so we can't use the same method to identify them. Instead, we use a proxy method, which is we look at birth to Mexican and Central American non-citizens 18 years or more in the past. So this is children who were born more than 18 years ago inside the United States. And we estimate there is about 340,000 or so unauthorized immigrants additionally who fit this qualification. So if you add the 3.3 million still living with minor children, our estimate of about 300,000 who do not live with their older children that are U.S. citizens, together you get about 3.6 million. Now we call these estimates of potentially eligible people because we don't have full information on continuous residence. We just know when people said they came to stay in the U.S. We don't know if they've gone back and forth since that time. And we can't model disqualifying criminal convictions. And when I've spoken to people in the field who provide legal services for DACA applicants, they often aren't able to qualify because they have a certain kind of criminal conviction. So in that sense, some of the people that we're modeling as eligible might not be so under some of the technical rules of the program. Okay, now we look a little bit broader. As we know, unauthorized immigrants often live in households with people of a variety of different statuses. And about 10 million people live in households with DAPA-eligible individuals and their minor children. That includes the 3.3 million potentially eligible for DAPA, about 4.3 million minor children, and 2.3 million other adults, usually spouses, but sometimes other relatives or even non-related adults in the same household. And then we have the 340,000 unauthorized immigrants who don't live in these households who are qualified for the program based on our estimate of having older U.S. citizen children. Altogether, that adds up to 10.2 million people. Now, in this chart, if we look at the statuses of the people in the household, the minor children are virtually all citizens or LPRs, close to 90%. And of course, that makes sense because there has to be at least one U.S. citizen child or LPR for the parent to qualify. But there is a small number of unauthorized children in these households. They're generally the older siblings of the U.S. citizen children. When we look at the other adults, of course, most of them are unauthorized. This is excluding other people who may be eligible for DAPA, but there are unauthorized immigrants who are not eligible for DAPA in the same households, and there's a small number of LPR and U.S. citizen adults as well. Now we look at the distribution of DAPA-eligible parents across the country, and they are highly concentrated, even more highly concentrated than the general unauthorized population. And the reason why is that unauthorized immigrants are more likely to be eligible for DAPA if they're of Mexican origin. That means they're more likely to have been in the country longer, established roots, and had families with U.S. citizen children. And that's why California and Texas really stand out. California alone has 1 million, or 30% of all potentially DAPA-eligible parents. Texas has another 500,000, or about 15% of the total. And then after that, it's 6% or less even for the other remaining large states. Now I'd like to spend a few minutes describing the characteristics of potentially eligible individuals and their families. First of all, a lot of them have a lot more than the required 5 years of residence. In fact, we estimate 69% of the potentially eligible population has been in the country for at least 10 years and a quarter for at least 20 years. If you look at the those that still have minor children living in the household with them, they're a little more recent, but generally follow the same pattern. But the small group of those with adult children, of course, those children have to have been born in the United States. They have to be at least 18 years old. So the vast majority of these parents have been in the country more than 20 years. So while the population is long settled, it is also not well educated. And here the differences with other immigrants are quite stark. So potentially eligible parents, about 80% of them have a high school degree or less education, and nearly 60% have less than a high school education, that is, don't even have a high school diploma. You compare that with all immigrant parents with minor children, and about half of them have a high school diploma or less education, and that figure is only about a quarter for U.S.-born parents with minor children. So, of course, lower levels of education alongside lack of legal status, and what I haven't shown you here in the presentation, which is relatively limited English skills, all of these things put DAPA-eligible parents at a disadvantage in the U.S. workforce. It means they earn less and their household incomes are quite a bit lower. So here we're looking at family incomes for families with DAPA-eligible parents in them. Income on average is about $31,000. That compares to $43,000 for households with children with all immigrant parents of all different statuses, and $47,000 for households that just have U.S.-born parents. So you can see that these DAPA families have about 2/3 of the average income for all families in the U.S. Of course, lower incomes means higher poverty rates in these families. So about 36% of families with DAPA-eligible immigrants are below the federal poverty level. That compares to just 22% of all immigrant families and 14% of the U.S.-born. So the poverty rate is more than twice as high for DAPA-eligible families as it is for the U.S. average. We also include, if you look at the purple bars on the slide, for purposes of educational institutions, schools especially, the share with incomes below 185% of the poverty level, which is the official low-income definition at the U.S. Department of Education. And here about 2/3 of all DAPA-eligible families meet that guideline. Before we get into the next part, I'd just like to say that if you look at the brief, we reviewed quite a bit of research that links unauthorized status, fear of deportation, lower incomes, higher poverty, and other factors in DAPA-eligible families to lower outcomes for children. And of course, one of the main purposes of the DAPA program is to promote the well-being of these children who are primarily born in the United States. So one thing in that regard that we did was to estimate just how much families could benefit from work authorization that would be granted to DAPA-eligible parents. So the first thing we looked at was parents' labor force participation, and we expected that with work authorization, maybe it would go up, but that's not what we found. In fact, if you look at men at the upper left corner of the chart, potentially DAPA-eligible men, 95% of them are already in the labor force, and of those, 93% are working. So there really isn't any room for improvement there. If you look across that top row, in fact, labor force participation of DAPA-eligible men is quite a bit higher than it is for LPR men. Women, however, DAPA-eligible mothers, only half of them are in the labor force. And of those in the labor force, only 85% of them work. So we could anticipate that there would be some improvement. You can see that LPR women are about 10 percentage points more likely to be in the labor force. But most of this gap in labor force participation is due to other factors like age, like having children, educational levels, which, as I showed you earlier, quite a bit lower, English language proficiency, time in the U.S., and other factors. When you model all those factors in, there's only about a 4 percentage point difference in labor force participation between DAPA-eligible mothers and LPRs, and that really suggests there's very little room for improvement with work authorization, and even that 4% didn't come out statistically significant in the model. What was significant, however, is a potential boost in earnings, particularly for DAPA-eligible fathers with a grant of work authorization. And that's, as you can see in this chart, LPR adults versus potentially DAPA-eligible adults. Men earn about $10,000 more on average, and women about $8,000 more on average. If you look at sort of the second panel in the middle of this chart, about half of the difference in men's earnings we modeled was due to age, education attainment, English proficiency, and other characteristics, but the other half was not. And we assume that most of this is due to work authorization. This is consistent with a whole range of other studies on the population legalized in the 80s and 90s, on the temporary protected status population that suggests that work authorization and or legal status could substantially raise earnings for men. For women, however, almost all the difference is explained by other characteristics, 7 out of 8,000. So we don't feel that there's a huge boost in income for women. Next, we model how the small boost in women's income of about $1,000 annually and men's income of $5,000 annually, together how those affect the average DAPA-eligible family. If you model them together, and this includes all families, whether they're two-parent families or one-parent families, so in some cases the families only have mothers, and so they don't get as much of an earnings boost. Altogether, on average, about $3,000. That raises family income from $33,000 to $36,000, almost a 10% gain. At the same time, of course, poverty rates would fall. We estimate by about 6 percentage points from 36 to 30%, which is a significant improvement in well-being for some children in these DAPA families. Now, finally, we also estimated what would be the change in family income if a father were deported. We only look at fathers because mothers are very rarely deported. 91% of all the deportees are men. We have to look at two-parent families, though, so we limit the analysis to two-parent families here because the one-parent families only have mothers, the father's already not present. So the mean annual income for two-parent families is $33,000, and if you subtract all of the father's earnings, if the father gets deported, that leaves family income at $9,000 for a 73% drop. This huge drop is consistent with field research that I and others have conducted in the aftermath of enforcement actions when a significant number of fathers have been deported. Quite often, the family loses all of its income because the mother doesn't even work. This decline in income of 73% would move the average two-parent DAPA-eligible family from 134% of the federal poverty level, which is the maximum threshold for eligibility for food stamps and Medicaid, to 49% of the federal poverty level, which we sociologists would consider to be deep poverty and well below the threshold for most public programs. Now, in conclusion, our estimate is there's about 3.6 million unauthorized immigrants potentially eligible for DAPA, that is, that are not already eligible for DACA. About 10 million individuals would be affected because they live in households with the eligible population. The eligible population mostly has very long U.S. residence, in many cases more than 20 years, but low educational attainment and high poverty. The grant of a work authorization has a very broad-based benefit for these families. It would increase the average income of the average family by 10%. Deportation would, on average, decrease, of the father, would decrease income by 73%. But this last scenario that we model, I really want to emphasize this before closing my remarks, is very rare. It's rare because at the same time in November 2014 that DAPA was announced, there were new enforcement priorities announced that have almost exactly the same qualifications and criteria. However, officers in the Department of Homeland Security still have discretion even within those enforcement priorities. So it is still possible that someone who's eligible for DAPA could be deported. It's just highly, highly unlikely. And my final point on that is that the literature suggests that the threat of deportation, no matter how unlikely, because it would be so devastating for families, does have a strong psychological impact on parents and children. And one of DAPA's other major benefits would be to lift that threat and lift that psychological burden. Thank you.
Thank you so much, Randy. And let me just, before I turn to Cristina, remind you all that if you would like to submit questions, please do them through the Q&A box on the left of your screens by emailing them to events@migrationpolicy.org. So we just heard from Randy an extremely lucid presentation on the characteristics of the potential beneficiaries of DAPA and DACA Plus and the effect of the programs if they are implemented. But obviously, the programs haven't been implemented. They're enjoined because of a legal challenge. So the case is now before the Supreme Court, arguments to be heard on Monday, And all the briefs to the Supreme Court, both by the 26 states which have challenged the action and by the federal government, have now been received. Numerous amicus briefs on both sides of the issue have been submitted, and in an extraordinary development, the House of Representatives authorized the Speaker to submit a brief on behalf of the entire House, and that brief was also submitted by the House to the Supreme Court. And because of that development, which is extraordinary, the Supreme Court argument on Monday will go beyond the regular 60 minutes and go to 75 minutes to allow the Speaker to present the House's case in opposition to these programs. So, Cristina, tell us what legal issues are now before the court from both sides of this argument.
Well, there are a variety of arguments in the case that are consequential, not just for immigration law, but also for administrative law and the operations of the federal government. There's an important threshold argument whether the court should even be hearing this case, whether Texas and the state have standing to challenge the federal government's DAPA policy. And that question revolves around the question of whether the state has been injured such that it's justified in challenging DAPA. So Texas's basic argument is that its injury is based on a variety of sources. The most important one, the one that the Court of Appeals accepted, is that Texas has a policy of subsidizing driver's licenses, and it also permits recipients of deferred action to have driver's licenses. And so their claim is that DAPA, by dramatically increasing the number of people eligible for subsidized driver's licenses, would require the state to expend resources, and that is the source of its injury. It also claims that increasing the number of non-citizens who are likely to stay in the state would have consequences for health care spending, education, and law enforcement costs. So the government's response to this is that this is all a problem of Texas's own making, that it could simply change its subsidy policy if it didn't want to pay for the recipients of DAPA to have a subsidized license. And the government emphasizes that every change in federal law that incidentally affects a state law, if any such change could be challenged, and could be a basis for standing, that states could tie the federal courts in, states could tie the federal government up in federal court litigation based basically on generalized grievances, which would really undermine the federal government's capacity to do its job. The federal government also emphasizes an important issue, and it'll be interesting to see if the court is persuaded by this, that this decision that it's made to not enforce the law essentially against the population that is eligible for DAPA is a decision that's committed to agency discretion by law. And essentially what that means is that it's a decision that's unreviewable. It's for the executive branch to decide whether to enforce the law or not. And historically, the courts have not intervened in making those judgments because they are peculiarly judgments for the executive branch to make. That's a crucial threshold question, and none of the legal issues about whether the government has exceeded its authority would be reached if enough members of the court found that there was no standing. But on the merits, there are three important arguments. The first is a procedural argument that the federal government ought to have submitted DAPA to what's known as notice and comment rulemaking. The Administrative Procedure Act requires certain agency actions to be submitted to the public for the public to comment, and then in theory, the agency takes those comments into account when reformulating its rule. And DAPA did not go through that procedure. The second two claims are substantive. The first of those is that DAPA is simply not in accordance with law, that it exceeds the President's authority under the Immigration and Nationality Act, which governs immigration enforcement and regulation. And the second is actually a claim that the Supreme Court itself added once it granted certiorari, seeking briefing on an issue that had not really been present in the lower courts, and that's whether DAPA reflects the executive's failure to fulfill its constitutional obligation to take care that the laws are faithfully executed. And these last two claims are essentially claims that the President has not acted pursuant to law. So in the case, the way that the federal government is framing its position is that the executive branch, when enforcing the immigration laws, or any laws for that matter, has to make choices about whom to remove based on the limited resources that it has and its judgments about how those resources should be allocated. It characterizes DAPA merely as forbearance of removal and emphasizes that it's supported by a long history of very similar actions by the executive branch. A number of the amicus briefs also emphasize those actions. The way that Texas frames the case is very different. It does appear to be accepting that the executive branch can decline to remove individuals according to certain criteria, particularly on a case-by-case basis. But their claim is that the president and the secretary here have done much more than simply prioritize how to enforce the law. The secretary, they argue, has exceeded his authority or her authority under the INA by conferring lawful status on those who are unlawfully present under the terms of the INA, and also conferring on them substantive benefits, the work authorization that Randy talked about, as well as access to a small number but important number of public benefits. So I'll just briefly consider each of the arguments and what each side is claiming. On the notice and comment claim, again, the question of whether the administration violated the Administrative Procedure Act by not notifying the public that it was considering this policy and then inviting comment, the answer turns on whether DAPA constitutes what's known as a legislative rule versus a general statement of policy. A legislative rule looks a lot like a law. It's substantive in nature. A general statement of policy really just advises the public of the manner in which the agency proposes to exercise its discretion. It's a somewhat murky area of the law, and whether notice and comment was required depends on whether the government's actions were binding in some sense, the guidance was binding in some sense. So Texas, and also the Court of Appeals in this case, emphasized that the public has an interest in providing input into a major immigration policy change, and argues that DAPA, the guidance that was issued by the Secretary, effectively constrains discretion because it's binding, which is the hallmark of a substantive rule. And it bases this on evidence from the implementation of the DACA program, where there was a low denial rate, as well as the operating instructions of DAPA that are very detailed and seem intended to cabin the judgment of lower-level officials. And they finally argue that even if there is discretion left in the system, it remains a substantive rule because it affects individual rights and gives people access to benefits. Not surprisingly, the federal government has a completely opposite characterization. It's a general statement of policy, they say, and importantly, and this is in the guidance itself, the Secretary can modify or revoke the guidance at his discretion, and they argue that means it does not bind regulated parties or the courts in any way. And another key characterization that's important to understanding the government's position is that the Secretary, they argue, is the entity who has discretion, and he exercised his discretion in defining the criteria for DAPA that you and Randy both listed. And it's that which reflects the discretion that's being exercised. But apart from that, the line-level officials who are actually implementing DACA, they emphasize, do actually have discretion to depart from the criteria. One of the elements of the guidance is that if granting DAPA would be inconsistent with enforcement priorities or other goals of the administration or the act, then that application can be denied. So if the court were to decide the case on the basis of notice and comment and determine this was a legislative rule that should have been submitted to public comment, then it could simply send it back to the lower courts and therefore to the agencies and allow the government to go through the notice and comment process. Of course, for this administration, time is running out, and so that could be cold comfort, but it would still provide an opportunity for the government to move forward. So as for the other claims that the President and DHS have acted not in accordance with law, both the statutory claim that he's exceeded his authority under the INA, the Secretary has, and that the President has failed to take care that the laws are faithfully executed, revolve around two conceptual issues that have crystallized at this stage of the litigation. The first of those is the question of whether what DAPA is the granting of lawful presence to its recipients. The DAPA guidance contains a sentence that Texas has seized upon that says deferred action means that for a specified period of time, an individual is permitted to be lawfully present in the United States. And both the Fifth Circuit and Texas have seized on that language of lawfully present. And they argue that DAPA is not mere deferred action, which is something that DHS and before it INS have used to defer removal. Instead, it confers lawful present status and makes lawful conduct that was unlawful or is unlawful under the statute, and that exceeds any conceivable authority the Secretary has under the statute. The Immigration and Nationality Act lays out a very elaborate system for getting status, and recipients of DAPA do not fall within any of those parameters. So the government responds in its reply brief in particular by saying this characterization is just plain wrong. Deferred action does nothing of the sort. It does not confer the right to remain lawfully in the United States. Recipients are subject to removal at any time, and that's written in the guidance, and they have no defense to removal. All that deferred action means is that the presence of recipients is being openly tolerated. And that's what lawful presence means in that line in the guidance. It's a term of art. It is not an attempt to grant any sort of status under the statute. It is the deferral of removal and the open toleration of presence during that period of deferral. So if we accept the government's characterization of what deferred action and DAPA actually consist of, then the Texas argument essentially collapses into a second claim that even if that were the case, what the government has done is to confer benefits. And that's very different from simply deciding to decline to remove someone. And those benefits, as Randy's presentation underscored, primarily include work authorization, but they also include access to certain Social Security benefits, Medicare benefits, and railroad retirement benefits. So the argument that Texas makes is that the government has impermissibly given access to work authorization and these welfare benefits, that you have, in both cases, statutory schemes that Congress has enacted that work very specifically through who is authorized to work in the United States, and also emphasize that only lawfully present aliens may receive certain benefits at the discretion of the Attorney General, and that by extending both of these benefits to the recipients of DAPA, the President and the Secretary have exceeded their authority. So the federal government responds, and again, it's responding by recharacterizing what's actually happening by emphasizing that these benefits, the work authorization and the public benefits, all flow not from the DAPA guidance, but from pre-existing statutes, regulations, and policies. That DHS and before it INS have authorized recipients of deferred action and similar types of policies to work in the U.S. since the 1970s. This authorization began for pragmatic reasons to enable self-sufficiency on the part of those who were allowed to remain, whose remaining in the United States was being tolerated. It was embodied in regulation in 1981, and then eventually the authority of the Attorney General to authorize non-citizens to work was recognized by Congress in 1986 when it adopted the Immigration Reform Control Act that prohibited the hiring of unauthorized workers. And so what the federal government says is that even if there's a question about the interpretation of the statutes that authorize these kinds of benefits, that has nothing to do with the guidance. That would not invalidate the DAPA guidance. That would be about these pre-existing statutes and policies adopted by Congress and previous administrations. So before I conclude, I just want to say a couple of things about the Take Care Clause argument. The federal government does not spend a lot of time on it, in large part because the arguments that are made about the federal government exceeding its authority under the INA are essentially the same style arguments you would make to demonstrate that the government has either failed to faithfully execute the law or has in fact faithfully executed the law. But there is an important characterization by the federal government under the Take Care Clause umbrella. And it's emphasizing there that the duty to see that the laws are executed is a purely executive and political act, and it's not subject to judicial discretion. It's important to understand that deciding how to go about executing the laws is something that's committed by the Constitution to the president and not something the courts can second guess. And for good measure, the federal government adds that the president has been faithfully, and the secretary, faithfully and zealously enforcing the law, using appropriations given to it by Congress to remove hundreds of thousands of non-citizens a year. So the notion that the immigration laws are not being enforced is somewhat fanciful. Texas, by contrast, argues that DAPA declares unlawful conduct to be lawful, and what that means is of constitutional significance. It means that the president is dispensing with the statutes and permitting the Secretary of Homeland Security to dispense with the statutes that Congress has enacted, and that is not something they have the authority to do. And in addition, it's for Congress to decide on whom to confer benefits like work authorization, not for the executive to decide. So it'll be interesting to see if this newly constituted 8-person court splits 4-4 on this case, in which case the Fifth Circuit opinion would be upheld, or if there is a majority. And if there's a majority on any one of the issues I've discussed, whether it's standing, notice and comment, or these merits questions about whether the president and the secretary have exceeded their authority, those holdings could be quite consequential, both for the federal government and for the administrative state generally.
Thank you so much, Cristina, and we are now ready for your question and answer session. Let me again remind people that if you would wish to submit a question, please do it through your question and answer box on the left of your screen, emailing it at events@migrationpolicy.org. And we have gotten a series of questions. Let me test 2 or 3 of them in one bunch. We've got a lot of questions that do we have these numbers that Randy presented for the top states for all the states. We have especially gotten interest from Nevada and Kentucky. So Randy, do we have numbers for all states?
Yes, and I can just tell you briefly, it's fairly easy to find them on our website. If you go to our main website, migrationpolicy.org, you go to the right-hand side of the page, just below the announcement for this webinar, there's something called In the Spotlight, and the second dot will lead you to a map. If you click on that map, you'll get to our data hub, and the right-hand side of that page there is an Excel spreadsheet which has our state-level estimates and county-level estimates for major counties for DAPA and DACA eligible populations. The other route is to go directly to our Migration Data Hub policy website, and again, there will be a similar map with unauthorized estimates. Nevada ranks number 15 with approximately 48,000 people eligible for DAPA, 18,000 for DACA, including the extension, so a total of 66,000 for the 2 programs. Kentucky's a lot lower on the list with 13,000 eligible for DAPA, 5,000 for DACA, including the expansion, a total of about 17,000.
Okay, thank you very much. We have gotten a number of questions praising us, the numbers that we have presented, and asking us whether we'll be testifying before the Supreme Court on Monday. No, unfortunately, the Supreme Court hasn't invited us to testify. We don't take any side on this case. But the numbers are available for everyone to see, including the distinguished justices and their clerks. Let me turn to one more question we have received on what is the difference between participation in the labor force and employment. Is there a distinction without a difference?
Yes, it is, and I don't know if I can pull this back up. It'll be easier to see it if I show. It's basically a simple distinction, and this is the way that the official U.S. economic statistics do it. I'm sorry, I'm going back and forth quickly here because I'm trying to find the right slide. Basically, people are either in the labor force or they're not in the labor force. They might not be in the labor force for various reasons. They have kids, or they're disabled, or they've given up looking for work. And then if they're in the labor force, they can be either employed or unemployed. So there's a labor force participation rate out of the total population, which is the top line in this chart, And then among those who are in the labor force, there's an employment rate, which is the second line of the chart.
Great, and now we have a question I would like to pose to Cristina, that DACA, which has obviously been implemented for the last 3 years and did not meet a successful challenge. There was a challenge, but was not legally successful. Does that create any precedent for DAPA or extended DACA?
So I think that the court will consider the questions in the DAPA case on their own terms. Whether they're standing or whether any of these other legal claims made by Texas have merit will depend on the details of this particular case. It is possible that if the court finds DAPA to violate any one of the elements of the law that has been invoked, that could present a problem for DACA. And if a state, having been found to have standing, decided to challenge that policy, it may be that the legal analysis that the court applies to DAPA might also apply to DACA. There are distinctions between the programs, but it's not clear that they're meaningful enough to separate whatever legal conclusions the court draws in DAPA from DACA. But I don't think the court will draw from the lawsuits against DACA any support for their conclusions in DAPA, in large part because those were all dismissed on threshold questions like standing and subject matter jurisdiction.
Okay, we have a set of questions to Randy. Can we multiply the average income gain from DAPA by a state's eligible population to get to a total income gain for the state?
Yes and no. I mean, I think that given that we haven't done any other research at below the national level, I think that would be a rough estimate. Obviously, incomes are going to vary across the country, and so the income gain might not be as great in a state where the unauthorized make lower incomes, or actually where immigrants with work authorization make lower incomes than in higher income states. But as a general rule, I think that you could use these income gains as the basis for economic impact estimates, yes.
So a related question, sort of, can we predict that DAPA population would engage in any educational programs and increase their educational level in order to increase the income if they're legally employed in the United States?
I think that we could predict that based on some research that's been done on what's happened with the DACA program. People become eligible for certain occupations that require licenses, and that enables them to take better advantage of higher education or ongoing schooling for the less educated. We certainly, I think, could anticipate that that would happen. I believe there's some literature also on the population that was legalized under the 1986 Immigration Reform and Control Act that also suggests that people seek additional educational attainment. Our earnings estimate of a 16% boost for men and income estimate of 10% boost for families is not based on improvements in education. It's based on improvements given that education stays constant. So that would be additional earnings and incomes gains above and beyond what we modeled.
Thank you, Randy. And a couple of questions we have gotten for Cristina. Cristina, I think one of them is relatively easy, I guess. It's does Justice Kagan need to recuse herself in this case?
She does not. She was not Solicitor General when any of this happened or when DAPA was formulated, so she does not need to recuse herself.
Great. And if the Supreme Court rules in favor of Texas or reverts the case back, will this restrain the implementation of a similar policy or law in the future?
It certainly could. I think anything that has the core characteristics of DAPA would be immediately challenged were a future administration to try to implement it. The one caveat to that is if the court divides 4-4, as I suggested before, that means that the Fifth Circuit's decision will be upheld or affirmed by an evenly divided court, but there would be no Supreme Court precedent on the subject. And so a subsequent administration could attempt to adopt a similar but somewhat different policy that's not covered by the injunction and have that litigated up to a court that had the full 9 members once, if and when someone is confirmed to Justice Scalia's seat.
And as long as I have you, Cristina, again, a question for you. What public benefits would DAPA recipients become eligible for? And sort of programs, especially which are federally funded or funded through a combination of state and federal funds?
So the main ones at the federal level are Social Security retirement benefits, which fall under Title II of Social Security, certain Medicare benefits, and then railroad retirement benefits. These are primarily programs that workers pay into, and so their eligibility for them is greater, and DAPA recipients, under the administration's interpretation of the statute that governs those provisions, would be eligible. People who receive deferred action are also eligible for a variety of state benefits, but that varies from state to state. States are permitted to extend benefits to unauthorized immigrants or to people in deferred action status if they so choose, as a matter of their own law. One of the benefits that's currently being debated is whether the states that extend in-state tuition benefits to unauthorized residents of those states could extend their policies to cover those who are DAPA eligible, or whether people who are DAPA and DACA eligible would fall under general in-state tuition benefits. But there are myriad benefits at the state level that could be implicated by having deferred action status.
Randy, let me just pose a question to you we received, is that sort of, for example, you find that the effects of DAPA for women are small or non-existent, but might the effect on LPFR or income for larger for single women and female households be different?
I think they absolutely would. I mean, most of these households, the vast majority that we modeled are 2-parent households, so they do rely heavily on the father's income and the mother's not working in about, half of the population, about half those cases, and that, of course, strongly influences our results. I would expect that in single-parent households, a lot of times that the mothers do work, and that the earnings gains and income gain would be greater, but probably not at the same level as it is for men. There is a pretty significant gap in general between what unauthorized men and women earn. And if you look at stuff that's come out more recently in general in the Latino population, there's a pretty high gender gap in pay. So I think because of that gender gap, the boost in income for women in single-parent households would be modest. Again, the labor force participation impact, I would think that those women are already working in a lot of cases. I don't see, and if they weren't able to work before because of child-rearing responsibilities and other things, I don't see that changing significantly. I would say, however, for more on this, there's a study by Pia Arrhenius at the Federal Reserve Bank of Dallas, Texas, that looks at the differences in income and earnings between El Salvadoran immigrants eligible for TPS and those without status, and does find some differences in labor force participation for women. And so I would refer you to that study, which has a slightly different methodology, that there may be some evidence outside what we've looked at that indeed labor force participation for women could rise.
Great. Cristina, I'm going to combine 2 or 3 questions we have received for you to answer collectively. First is that obviously since the Supreme Court granted the cert, one huge difference is the absence of Justice Scalia because of his passing. So the questions are, what impact will a 4-4 tie decision have? Related to that is that if that means that the Fifth Circuit decision stands, will the government have the option of implementing DAPA in other circuits? And then related question is that if there is a Republican winner in November, what impact will that have on both the DAPA and extended DAPA and potentially even on DACA? Essentially, is there any threat that those people who have already gotten their DACA benefits could lose them?
I think Justice Scalia's absence from the court will certainly affect the oral argument. I think the oral argument would have been very different had he been there. As I'm sure a lot of people remember, during the litigation over United States versus Arizona, Arizona's SB 1070 law, he expressed very strong opinions, not only about the validity of Arizona's law, but also about DACA, which at the time had already been announced and had begun to be implemented. And so I think that we'll be missing a certain rhetorical approach to the federal government's position in this case because of his absence. I think that, well, I know that if there's a 4-4 tie, what happens is the Fifth Circuit's decision is affirmed by an evenly divided court, but as I suggested, it's not precedent. And so the questions underlying the case all remain unresolved. The problem for the federal government is that the district court issued a nationwide injunction, which was part of why it was so concerning to the federal government that a set of states could, in one district, enjoin a nationwide program, even though there are just as many other states who would welcome DAPA. So if the Fifth Circuit's opinion stands, the Fifth Circuit upheld that injunction, then this administration would not be able to implement DAPA in other circuits. What would be required would be some sort of reformulation of the program and a willingness on the part of the new administration to attempt to enact it, presuming that it could distinguish it enough not to fall within the parameters of the injunction. If a Republican wins the election in November, I think it likely, just based on the way the debates have gone and the way their platforms are shaping up, that the DAPA guidances will be rescinded and that policy will be completely abandoned. I do think, however, that any Republican DHS will need to prioritize enforcement, as any DHS does, and I think you're likely to see guidance memos that look very similar to the ones that this administration has relied on, irrespective of DAPA, to guide how to spend limited enforcement resources, emphasizing people who've committed serious offenses over people who have merely committed status offenses and have families in the United States. The big question, though, is DACA and whether a Republican administration would dismantle it. And I don't know that any of the candidates have taken a position on DACA and whether it should be undone. I think that it's likely, or at least possible, that once the current authorizations for work and the periods of forbearance expire, that a new administration that's Republican won't renew them. But the political costs of that might be tricky. People have entrenched interests around DACA now, and so it might be difficult for an administration to take that kind of a position, which will certainly engender outcry. And I think it will depend a lot on what else is happening at that particular moment in time and what that administration's other priorities are, what Congress looks like, and what it might be trying to do with Congress. So there are a lot of factors that will affect the way a Republican administration approaches the DACA program, which has already been implemented.
Okay, folks, let me warn all of you who are still with us, and a huge number of you are still with us, that we got a number of questions. And just because the Supreme Court in this extraordinary case decided to extend its argument by 15 minutes, we have decided that we'll extend the question and answer series here by a few minutes more. So please be more patient. We will get to your question. Cristina, as long as you're still on the hot seat, there are a number of questions asking you that, since you're a former Supreme Court clerk, could you predict how the Supreme Court is going to rule? So be my guest.
That's a good question. It's been 12 years since I was on the court. It's a different court now than it was before, but I have some intuitions about what we're likely to see. It's quite possible that you'll have a majority of the justices find that Texas's standing arguments are a bridge too far, and that if they were to accept them, it would open up the federal government to a lot of litigation that would be potentially crippling. And so I do think there's a reasonable chance that the court will decide the case on those grounds. I also think there's a chance that it will decide the case on the notice and comment ground and simply send it back to the lower courts and the agencies to go through a notice and comment process. If we're seeking to delay resolution of the merits questions until a new justice was confirmed, then that could be a strategy. The only difficulty is that my view of the notice and comment arguments is that requiring notice and comment with this sort of a policy, which is an attempt to cabin enforcement and supervise enforcement, would impose a significant cost on agencies generally. So I'm not sure that as a matter of administrative law, they would be willing to go there. On the issues that people generally care the most about, the legal authority questions, I think it all depends on which of the frames the court accepts. If the court accepts Texas's frame that this is not just forbearing removal, it's granting lawful presence status and conferring benefits so that it looks legislative or it looks like it's beyond the scope of enforcement authority under the INA, then you might have 5 justices who find that this is different from anything the government's done in the past. I think, however, though, that characterization is based on a clear error in interpretation of immigration law, and hopefully that will come through in the litigation. And I do think that there is reason to think that a couple of the more conservative justices would actually regard what the executive has done here as consistent with their view of the enforcement power and of what the executive branch does in immigration. In the United States versus Arizona case, Justice Kennedy articulates a theory of executive discretion that Congress understands that the executive is going to exercise judgment when enforcing the law, taking into account humanitarian concerns, foreign policy concerns, and that role that the executive plays is one that requires some degree of latitude. So the question then becomes, is the latitude that the administration has taken here too much for the justices to see that as the appropriate role of the executive branch? So I think if they get past these threshold questions, will come down to that, whether they accept it as conventional or traditional exercise of enforcement discretion.
Great, thank you, Cristina. A couple of questions for Randy. Randy, first about North Carolina. Do you have any total income impact in North Carolina?
We didn't estimate total income impacts by state, no. So I think that we talked about this before as far as the methodology is concerned. North Carolina has about the 8th largest potentially eligible population, so it is a heavily affected state, potentially by this policy. But we haven't calculated total impact estimates at the state level. And sort of a question on the methodology, that the analysis of income gains doesn't identify a specific single mechanism that produces the increase in income. I think that's correct, yes. It's a method where we look at all the factors that we can measure in the data that are not related to legal status. So that, again, includes age, educational attainment, English proficiency, and some other factors. What's not explained by those other measurable factors in the data is what we assume to be primarily the impact of unauthorized status and lack of work authorization. That level of gain, which again for earnings for men is about 16% and for household incomes about 10%, is consistent with what other studies have shown. For instance, the Legalized Population Survey reviews of that, what happened to people who got legalized under IRCA when they got work authorization, and also, as I mentioned earlier, Pia Arrhenius' work on the impact of TPS versus unauthorized status on Salvadoran immigrants' earnings. Nonetheless, it is possible that other factors beyond work authorization are at play here, including just discrimination in the workforce and other things we couldn't measure in the data.
Great, Randy. And back to you, Cristina. One question about DAPA is that from what we know today about the implementation and the discretion that has been used in approving DACA recipients, has this policy leaned more liberally or more conservatively, or we can glean nothing from the record?
If the question is about whether the decisions by the agents within CIS, USCIS, who are implementing it are leaning more liberally, I would say that the vast majority of applications have been approved. And so there, I think, is a tendency to implement the program in a capacious fashion. There are a lot of reasons for that, including that the people who have applied are a self-selected group who know or are fairly confident that they meet the criteria. And it's also the case that the agency is engaging in a kind of supervision and direction of officials, even though they retain the discretion to deny applications. But the overwhelming trend has been in favor of granting the applications of people who meet the eligibility criteria. And so in that sense, it has been a liberal implementation.
Thank you, Cristina. Let me just ask you two more related questions. One sort of, I guess, go back to 101 administrative law. What authority did the Federal District Court in Texas have to issue a nationwide injunction? And let me just ask you that first.
I believe the rationale was that it was a nationwide policy, and therefore, because the decision addressed the metes and bounds of that policy, there was no reason to limit it to the state of Texas. So the fact that there are other states who would welcome DAPA is immaterial if what the government has done is illegal. And so the district court was evaluating a single policy by the federal government and therefore enjoying that single policy.
And sort of on the technical aspect of the case is that how likely is the court rules in the majority on the procedural argument based on the Administrative Procedures Act, on the reasoning that DAPA will have $100 million economic impact on Texas. Does the court ruling that DAPA was significant and substantive rulemaking?
So I'm not sure that the economic impact on Texas will affect the decision whether this should have been subject to notice and comment rulemaking. That will depend on the characterization of the policy. Is it a substantive legislative rule, or is it just a general statement of policy meant to announce how discretion is going to be exercised? It's certainly possible that these questions of impact on the states will inform the court's judgment in some general sense. They'll provide atmospherics. So in the United States versus Arizona case, even though Justice Kennedy struck down, or the court, with Justice Kennedy writing, struck down most of the state statute, the opinion did emphasize the costs that unauthorized immigration impose on states. And so whether that will turn the court's legal judgment, it's not clear. I think it's most likely to have an impact at the standing stage where the states are trying to make the claim that they have suffered some kind of injury and that their costs fall within the zone that the Immigration and Nationality Act is supposed to protect, or that statute implicates. And so it might play a role in the way the court approaches those questions, but it won't be in either direction a decisive factor of any kind.
Thank you, Cristina. And I think we will take this as the last question for the day, and back to Randy on his presentation. Has the data been updated on the profile of the unauthorized immigrants since it was first released? Are the numbers different than in the original report by state and county breakdowns?
Well, we currently have on our website our data through 2013, and that's the same data that we use in the report, but we are in process of updating to 2014 data. The latest of data available from the American Community Survey that just came out in the fall go through 2014, so we're in the process of that right now, and hope to have something out with updated profiles through 2014 relatively soon.
Thank you, Randy. I think I failed to ask the question early on. This is, again, sort of an interesting procedural question for you, Cristina. If DAPA is allowed to proceed, is the government able or likely to change the date requirement, like the date of entry, date of birth, at all given the delay in the implementation?
It's hard to answer that question. I'm not sure. I suspect that they will implement the policy as written to the extent that they can, because there's a limited time left to implement, and because they might be concerned that any deviation could raise some sort of scrutiny or suspicion. But it may be that that sort of change is uncontroversial, and if they get the legal go-ahead, they could make minor adjustments of that sort. But it would change the arrangements that they might have made to begin implementation.
Thank you, folks. I think we will conclude, despite the fact that number of questions we haven't been able to answer, we should conclude. We have gone 10 minutes over. Thank you to everyone who had the patience to stay through the end. And again, to remind you that the audio recording of this webinar will be on our website later today, migrationpolicy.org. And the report that Randy presented, Deferred Action for Unauthorized Immigrant Parents, Analysis of DAPA's Potential Effects on Families and Children, is available on our website. If you're a reporter and have questions still, please contact our Director of Communications, Michelle Middlesat, at 202-266-1910. And I really want to thank Lisa Dixon, our events coordinator, for making this happen and making it so seamless. And thank you all for joining us, and happy argument on the 18th, and we'll look to the outcome of the case. Thank you again.